So that's a review of what played out in the judiciary or that sector, which is quite critical for everyone. We talked about the rule of law when we started off the program, and that's our focus, judiciary, and all the decisions that were made, the impact it had made, and it will make in 2026, and what we'll be looking out for. And I can tell you for free, political litigations is one of those things we'll be looking out for as far as the election season is concerned, and we're expecting it as soon as possible. But let's bring in our guests, two senior advocates of Nigeria, right here in our Lagos city. We have Senior Advocate Wahab Shitu joining us. Thank you, sir, for coming on the program, and then compliments of the season.
Compliments of the season. Thank you for inviting me.
And joining us virtually here in Lagos is a Senior Advocate of Nigeria as well, Mr. Yemi Kande Johnson. Thank you, sir, for coming on the program as well.
It's always a pleasure. Thank you. Good evening. Season's greetings.
Let me start with you, Senior Advocate Yemi Kande Johnson, on a quick review. Our report that you saw talked about the Nnamdi Kanu case, talked about other cases. In fact, there are other big cases that are happening. When we do most of this review, we look at the big highlight, but there are other subsidiary issues that have been decided by the court, which is one of the things that the report highlighted that has to do with backlogs and all of that. But I want you to give us your own overview of how you want to assess the performance of the judicial sector across civil cases and criminal cases and even political litigations, just like an overview.
Okay, well, the judiciary is people. And so obviously the credibility of the individuals who occupy offices who carry out the functions of the judiciary is relevant. And there's no judicial or legal system which is not a work in progress anywhere in the world. And ours certainly is one that is a work in progress. But I could assess it on the basis of events that have occurred and on the basis of steps that have been taken. But I started by saying I think that the people in the judiciary are the most important first point of contact for those of us who would deal with the system in any capacity, members of the public, members of the legal profession. And I think that it's my fair conclusion that while there are a considerable number of problems with the efficiency, the effectiveness, and the integrity of our legal system, that in the last year, and I think therefore going into 2026, a number of steps have been taken, which indicates, to my mind, that the current Chief Justice appears to have a clear vision for the reputation and effectiveness of the judicial system. And she appears to have the strength of character that is required to progress some of these initiatives, which would meet, in many cases, entrenched, I don't want to say behavior, but entrenched habits, which may be difficult to dislodge after several years. So, for example, the testing of the integrity of proposed judicial officers is something that has not been done in a public way before, with public feedback and testing the character of those who would aspire to judicial office. This is very important because the appointment of the judicial officers is critical to confidence, to the efficiency, to the effectiveness of the system. And secondly, another thing which I thought was very important, because public confidence in the judiciary is critical, is the decision of the court to summarize its decisions. And not every man on the street can read 700 pages of legal verbiage, but most educated Nigerians can read 5 or 6 pages of summary, which of course is what the House of Lords or now the UK Supreme Court does, because justice must be delivered to the ordinary man on the street, and he should be able to understand it. And sometimes the language of law is so obscure and convoluted that meaning is lost. And when meaning is lost, it's easy for suspicion to take its place. So I think that I would assess the judiciary at any stage on its efficiency, its effectiveness, and its reputation. And I think that there are some signs which may be encouraging in that respect.
Let me come to you. I guess what your fellow Leonard is talking about has to do with, which is quite important, the reputation, the integrity, because the judiciary itself is always on trial. They said when the case is before the judge, it's not just the case, it's also the judge that is on trial. And I remember lately, one of the things that was commended for what the Chief Justice of Nigeria did recently was about 62 names were submitted to to be called to the bench or to be judges at the Federal High Court, where 34 of them could not pass the integrity test, which is a good signal. But in your view, how would you assess the judiciary in 2025?
Well, I think largely the judiciary has fared very well. There are rooms for improvement. That we all know that there is no perfect system anywhere. But since the Chief Justice of the Federation, the current CJ, took over, particularly in 2025, we've seen remarkable improvements in terms of judicial integrity and independence. And more importantly, a conscious attempt by the judges to address the phenomenon of corruption. And you've just cited a very recent example, which is unprecedented. It's something that we have not seen before. Judicial appointments being advertised in order to get feedback from the public. And one of such feedback has led to the disqualification of a number of people, because it is important when you are talking about the judiciary to look at the issue of judicial independence as well as judicial integrity. It is important that we have a judicial system that engenders confidence, trust, and that is perceived not to be corrupt, but that people are willing to trust in. To the ordinary people and citizens are willing to say, oh, this is a judiciary that will deliver justice, because ultimately the destination is the attainment of justice. Justice is seen to be delivered when the average man, or woman, walks away with the feeling that justice has been delivered. So the test is really with the, it's an objective test, so that people must be able to trust the judiciary. The judiciary must engender confidence. The judiciary must be peopled by elements of integrity. And in terms of that, yes, we have not gotten to the destination yet. It's still work in progress. But we all know what the fundamentals are, what a judiciary ought to aspire to achieve under a democracy. You mentioned one of them, which is critical: respect for the rule of law. There's no way you can practice democracy effectively without adhering to this rule of law principle. It is when democracy conforms with respect for the rule of law that you say it is what the why. So, but when you have a democracy that subverts the rule of law, a democracy that is defined by corrupt practices and the lack of due process, then you say that's not democracy.
But sir, while from a survey that's online, while many agree that efforts have been made this year, getting the confidence of the people, a lot of people are very skeptical about political interference, and it's so tightly woven when you look at the political interference, the political players, and the judiciary.
Yes, it is undoubtedly clear that the justice system cannot command public respect if judges are perceived as dependent, intimidated, or vulnerable to influence. Like you have, but you see, it is work in progress. I think for us to be able to make progress, we should reinvest faith in the justice delivery system as a people. It's not good to proceed under the assumption that, the judiciary will not deliver justice. It's a two-way process. The people must donate confidence to the justice delivery system. In return, those who are saddled with the obligation of dispensing justice must live above board, must ensure that the process is fair, and that the people themselves are not corrupt, and that justice is delivered in a free and fair manner, in a manner that will engender confidence.
Okay. Well, let me come to you, Mr. Candy Johnson. When we started the program, one of the things that Jeffrey was saying is that politics definitely plays a huge role in everything that concerns us as a nation, and the judiciary is no doubt usually in the middle of it. So a good number of political cases happened last year. And usually it will be like people are waiting for what the judiciary will say to see exactly how the case itself will be perceived. The year opened, for instance, with litigations from 2023 into 2024, and then we had this, politicized issue of Nnamdi Kanu, the River State emergency rule judgment, and all those things. It's sometimes difficult, Mr. Candy Johnson, to excuse the independence or the fairness of the judiciary when the sentiments are high, isn't it?
I understand you to be saying that people will not trust the results of a judicial decision because they have certain expectations. Have I got you right? I think, first of all, that it's a mistake to judge the judiciary primarily on these high-profile political cases. The vast majority of work that judges do is in personal contracts, banking, commercial debt, even criminal law. I mean, the criminal law is at least as important for the stability and progress of society as political cases. But you're right. What people see most of all are these most sensational political cases. People take highly partisan views of the potential result without hearing the evidence, without listening to legal arguments. And people form views which become hard and entrenched, and they would be unwilling to accept a decision that did not conform to their own previous understanding. This is normal, but this is not a valid way to judge the judicial product.
By virtue of his legal training, that's why he or she aspires to that position of being a judge. So it is important for the lawyer to rise highly to the demands of professional standards and ethics.
Do we have a system to ensure that the lawyers are themselves above board? Because it raises questions sometimes.
No, the system, there's an entrance system. For instance, we have rules of professional conduct that, defines what the lawyer is supposed to do and what the lawyer is not supposed to do. The rules are there. I think the advocacy is not whether the rules are there or not. We all know the rules are there. I think the advocacy should be, enforcing those rues.
It begs the question.
Yes.
Do we know that, you lawyers tell us, some of you tell us that it should be difficult, if not impossible, for a lawyer to be judging the judgment, if I can put it that way, of the Supreme Court. But a good number of cases have happened in this year that we've had legal practitioners come out and say, guys, I don't agree with the judgment of the Supreme Court and all of that. And it leaves the citizens, people who, like us, who don't know much about these things, wondering exactly, if we can't trust the judiciary, then who do we trust?
Well, the question is not whether we can trust the judiciary. And the question is not whether the judges can be criticized. In all civilized jurisdictions around the world, judgments are subjected to public criticisms. You understand me? The fact that judgments are criticized is not in itself what is wrong. It is when you criticize a judgment based on wrong premises. For instance, some of the commentaries you see on air by lawyers, some lawyers, not all lawyers, are commentaries that are made without being informed. For instance, you should know how the judice functions. Before you can criticize the judgment, you must be privy to the processes. You must be privy to the record of proceedings. You must be privy to the arguments advanced. And then you must also be privy to the justification for the judgment. In every judgment, there's a justification. If a judge makes a pronouncement on any issue, there must be a justification for that pronouncement. That is what you interrogate if you want to do a fair critique. You understand me? You cannot come on air to criticize or undertake a critique of any judgment if you yourself, you have not taken steps to read the judgment. And most times, most of these criticisms are offered in the public space without the benefit of reading the judgment. So I think the advocacy is that it is not wrong for us to criticize because judges are human beings. They can make mistakes, and it's only when we criticize them, some of these mistakes, that they can improve their performance. But those criticisms must be fair, must be objective, must be constructive, must be informed. If you don't, for instance, if you don't read a judgment, and then you come on here to criticize the judgment, that would be an unfair assessment.
Okay, let's build on that, Mr. Candy Johnson. Let's bring you in on this particular issue of this judgment. So I have two cases, and funny, those cases are from the same state, Rivers State, where there was an incident of the defection and whether there was no defection, appropriation bill. Now, the judge, one of the justices of the Supreme Court, has said, look, as we see that, okay, you're saying that this case is not before the court, but when you're talking about the appropriation, the dramatics personnel involved in the appropriation brings that particular case before the court. So on that premise, she spoke on the issue of defection, which became a very controversial issue. We saw the issue of about emergency rule, or whether the Supreme Court has powers, or whether the president has powers to suspend elected officials, such as the governor, deputy, or the House of Assembly. Well, the Supreme Court did not exactly say yea or nay, but what they now did was what they now call it a discussion after the preliminary objection was upheld. So at the end of the day, it leaves everybody a bit confused. So my question is, what happens when we have judges speaking on issues that are not the main merits of the particular case, and then keeping all of us confused as to what exactly is the decision of court or the pronouncement of court, because these are not enforceable order of court, but it has become a statement that people are beginning to pontificate over, if you get my drift.
Okay, well, can I first of all comment on the subject of your previous discussion about the behavior of lawyers? I think that a fundamental weakness in our system of justice, a major reason for its inefficiency and for lack of confidence, is the inability of the professional system to hold senior lawyers accountable for bad behavior. This was a subject matter of a speech I gave maybe 2 or 3 weeks ago to Lagos Bar at their annual dinner. The fact is that there is a presumption, or there is an assumption generally, that senior lawyers who should be modeling the highest standards of professional behavior very often do not. And they have a habit and a reputation for escaping scrutiny. No one can tell me of a senior lawyer who has been successfully processed through the disciplinary process of the bar. Okay, 1 or 2 of them have faced criminal conviction for actions they've had. But this is a problem. By and large, senior lawyers think that they are not bound by the rules of the profession and that they can behave in a way that is beyond correction. That is a problem. If senior lawyers can be corrected and held to account, judges will know they can be held to account. Junior lawyers will know they need to be held to account. Many years ago, a famous lawyer called Fred Egbe, who did a famous libel case against Justice Adefaras, and then chief judge of the state, made the acid remark, which may not be correct, but it shows you where we might be going. He said the problem with the law in Nigeria is that the junior lawyers bow to the judges, and some judges bow to senior advocates. The fact of the matter is that senior advocates of Nigeria
sorry,
are the
Mr. Kandi,
principles
I want
it's
to
their
ask you,
responsibility.
sir. Mr. Kandi, sorry, I want to ask you. I mean, you're a senior lawyer, and you're saying that senior lawyers are not being held accountable. So, I mean, it's easy to say you're a senior advocate of Nigeria. What should be done? What moves are you making so that we see this actually come to pass? Because, I mean, for us out here, we can hardly do anything about this.
Well, speaking personally, I consider that if I make a professional mistake, if I act in a way that is not a proper model to juniors who follow and watch my conduct, I should be subject to reproach. As to what we can do, in many cases, well, there is a notorious case right now, and I am one of the complainants to the disciplinary committee about the conduct of a senior lawyer whose behavior has brought international disrepute to our profession. But the fact of the matter is that there should be more lawyers willing to do that. And we cannot if our house is not kept in order, we can't expect people to pretend that we're noble and honorable. It's not about wearing a fancy gown. We have a responsibility. The seniority that I have, I consider to be a responsibility. It's called a privilege, but in fact, it's a privilege that comes with a huge task. And I think that if senior lawyers, who are the most visible practitioners of law in this country, even more visible than the judges, if they behave in a certain way and it is wrong, if they're reproached, and if the idea is not that they can escape reproach, then there will be a model for others to follow. So yes, I'm a senior lawyer, and I'm perfectly comfortable to say that in my experience, senior lawyers too often model behavior which undermines the integrity of the legal profession.
Mr. Candy Johnson, so when you say bad behavior, maybe you give us specifics. And in addition to that, the question I asked about the judges. So I gave a classic case where a preliminary objection was upheld, yet the judges still went ahead and spoke on the substantive issue. That should have ended, and it became a controversial issue today where everybody is choosing and picking as to what the judges have actually said. And this is at the highest court in the land.
Yeah, well, that's a problem for the Supreme Court. The Supreme Court, giving a pronouncement, ought to recognize the whole range of decisions it's made before. It ought to recognize the potential impact of any comments it will make for cases that will come thereafter. This is why it's the highest court. Now, there's a problem. Another problem with the Supreme Court, of course, is that it's overburdened with a high degree of irrelevant and pointless cases. That is just a fact. I mean, I was told of a case of a one-room shop in Kuje, which went all the way to the Supreme Court, over 30,000 naira. This is a waste of judicial time. The Supreme Court should be deciding the idea of our law fundamentally and deciding principles which would apply across the board. But they have to be faithful to those principles themselves. It is not acceptable, and it undermines their own integrity and the public impression of them, if they give inconsistent decisions, if they give one decision and they don't follow their own advice. This is the most senior court in the land. If you expect senior advocates to conduct themselves with the highest degree of professional behavior, which I do, then I'm entitled to also demand that in the High Court and the Court of Appeal and in the Supreme Court, that they must recognize that consistency is the method by which precedent comes down to the public. If you know the way a court is going to decide the matter because it's spoken clearly on the subject, people are not going to contravene that position. But part of the problem we have now is that the variation in court judgments, even within the Supreme Court, is so unruly that people think they can take a chance. I'm going to go to court because maybe I'll roll the dice. The law is not clear. Judges are saying inconsistent things. I'll take my chance. It may favor me. This should not be the case. People should be worried to approach the Supreme Court because of the clarity and certainty of its judgment and the assurance that they should have that the law on the topic has been clearly stated and it will not be reversed. And then when lawyers bring cases which are frivolous and unfounded, then they ought to be punished.
All right, I think I should come to Mr. Shitu right here in the studio about what Mr. Candid talked about. Cases that are not supposed to end up in the Supreme Court actually do. I know that one of the innovations of this year is the mobile court, you know, and those smaller courts that are supposed to handle the smaller cases. But I wonder, I mean, as with so many things in Nigeria, we see it on paper, we talk about it, but how do we get these things done? Jeffrey just talked about, I mean, in the highest level of the judicial system where a judge had spoken and yet it didn't give a conclusion to it. So what does this tell us? Is it the connection man-no man issue that, you know, these cases are supposed to have ended somewhere lower in court? But I mean, do you know who I am? It takes it up to the Supreme Court.
Well, I found myself unable to disagree with eminent Mr. Candido Johnson, who I must say publicly is one of the most upright and well-respected senior advocates we have in terms of his, you know, knowledge, not only knowledge, adherence to ethics. And you see, and if you look up to, you know, elements like that as models, then it is very difficult for you to be able to misbehave, whether as a junior lawyer or as a senior lawyer. And I say this because of my deep respect and knowledge of him. But having said that, you must recognize that the reference that you made to recent Supreme Court judgment is very, you know, illustrative. I mean, you must recognize that the Supreme Court, as it is not just a court of law. It plays a tripartite role. It's a court of law, it's a court of equity or justice, and also a policy court. And that role as a policy court is also very significant. For instance, you mentioned this declaration of state of emergency in Rivers, and a preliminary objection was raised at the level of the Supreme Court, and the Supreme Court, dismissed the, preliminary objection, and still went ahead to make some comments about what you consider the merits of the case. Those comments were made to guide future conduct of lawyers on such cases, and I don't think it is out of the way for Supreme Court to make such pronouncement. There are certain areas that remains very cloudy in terms of, ambiguous. And then if you look at the Constitution, the way it is made, particularly the provisions on state of emergency, as contained in Section 308 of the Constitution, is too elastic. Those provisions, gives the president a lot of powers. So I think sometimes you don't blame the judge, like in this case. You blame the Constitution, the way it is worded. Yes, we need to tinker with the Constitution, and make an advocate for greater clarity in the way some of these provisions are couched, in order to forestall some of this controversy and the ambiguity that you have alluded to. And what the Supreme Court did in that case is to say the exercise of presidential powers under a state of emergency is quite extensive. And that is the truth. If you read the Section 308 very well.
Extraordinary measures.
Without extraordinary measures.
So the argument,
yes.
Without coming in, so 5 ways the governor can be removed that I know of. His tenure ends, I hope I can remember all of it. He's impeached, he dies, he resigns, and I think a court can remove him, maybe tribunal, those are. And if you go to Section 4, subsection 11, even when a House of Assembly cannot even function, there's a clear-cut statement by this Constitution telling the National Assembly, don't go near the governor and his deputy. So it looks like a closed case as far as how a governor can be removed or made tactically immobilize him to perform his duty. So this was a case where everybody was looking forward to say, let there be a clear pronouncement. Because when Joshua Darie went to court, the argument was to the fact that he doesn't have the local standard because he came in as a suspended governor. Similarly, Fubara couldn't have gone in, he didn't institute the suit. Now his colleagues went and instituted the suit. It's also an issue of local standard. So everybody wanted informal closure, but it looks like that closure now, it's not as clear. Nuances of an obiter dictum in that conversation. They have said, okay, it didn't stop you to remove the governors, neither did he say you can remove the governors. So it depends on the measure of threat in this sense. And that gave room for multiple interpretation, even by lawyers themselves. So my argument is to the fact that if you were not ready to speak clearly on it, why do you speak on it entirely?
Well, I don't think, without holding brief for the Supreme Court, when you say extraordinary measures might also entail suspending certain aspects of the Constitution during the state of emergency. You are talking of a state of emergency. Ordinarily under a state of emergency, rule of law at times may be kept in abeyance in order to deliver on peace and security. We are dealing with extraordinary times. And I think what the Constitution ought to have done is to set out the limits of powers that the president can exercise under a state of emergency, and to say clearly that it does not cover removal of elected governors. But that is not there. And now it now behoves on the Supreme Court to make such a pronouncement. And I think from what the Supreme Court has pronounced, it is clear that a president under the present Constitution can remove an elected governor. And it will not be derogated from the provisions of the Constitution.
Because of the latitude of
yes.
discretion.
That is why some people have said the advocacy should be for a brand new Constitution. So that we can look at some of these gray areas.
And you know, Mr. Shitu,
yes.
with some of these gray areas, and we are talking of, you know, winning the confidence of the people in the judiciary.
Yes.
I mean, if the experts, the senior advocates, are talking of gray areas, then how do you expect the people to have confidence in the system?
With due respect to you, it has nothing to do with the issue of confidence of the people. You look, you submit a dispute for resolution before the Supreme Court, and the Supreme Court has a duty to make pronouncement based on the letters of the law, and there are certain rules, prescribed rules, that are deployed for constitutional, interpretation. And one of the most fundamental rules is the purposive rule of interpretation. You look at the letters, the issues generally, and they make a pronouncement. I think instead of condemning the Judas, we ought to salute the Supreme Court for rising to the occasion most of the time to stabilize the polity.
Okay.
And that is one of the job, the assignment, and
there are one or two things I like us to begin to look forward to 2026, because one of the issues that is likely to take the issue. But before we go there, let me ask you, Mr. Candy Johnson, if there is anything you'd like to respond to in all of the issues that have been raised so far. Extraordinary measure is a very large space.
Our political history makes quite clear that the question of state of emergency has been problematic through all the republics. It was the Western region, it was a problem under the Second Republic, all these. It's a matter that was dying for a clear pronouncement by the Supreme Court. I think that it's idle to call a reasoned pronouncement of the Supreme Court an obiter dictum. There is no court in the land that will tell you that an expressed opinion by the Supreme Court on a subject matter is obiter dictum. I don't want to use the street expression. The street expression will be, they haven't born the father of the person. But the fact of the matter is that when the Supreme Court determines that it is going to consider a matter, and other courts do this is a matter that is likely to be problematic across politics. We now, whether there's a preliminary objection, whether the issue is viable in this case or not, we're going to make a pronouncement which must guide the profession and the politics and the conduct of this matter. Now, we need judges to be able to interpret the Constitution. This is a fact. The Constitution is written for all time, but it cannot anticipate all things. The United States Constitution was 7 articles, and since then 27 amendments, but this is what has run their country for nearly 300 years. Our Constitution has 600 or 700 sections because the drafters thought that they could contemplate every possible issue, and they were not willing to leave the interpretation in particular matters to the wisdom of the institutions that they had created. That is a problem. But the Supreme Court of Nigeria, I think, was quite right to step into the void, if you like, that exists in this area, this important area of our law, and to make a pronouncement which I would consider has declared the policy of the courts on the question. There is nobody who can contest it. So to say whether they had a right or not a right, the Supreme Court decided to sit in bank, and they decided to pronounce on a problematic legal political issue. They took time to consider and gave a decision. I think their decision is unimpeachable. But beyond that, I think that, again, it would be idle for anyone to say that was not the law of the land.
Okay. Well, I like the part that you said that they have not burned the fat. We'll come to that part. I don't know if okay, so there is an issue that is likely to come to the fore in 2026. The police has, the president has been talking quite frequently about the state of state police system and a number of other things. Now, how it concerns the judiciary, you may kindly show us a pathway, is something that a guest we hosted said about the issue, that state police, the issue of state police goes beyond just recruiting policemen. It includes the entire criminal justice system being reviewed. It includes the fact that the states now have to take responsibility for their judges, for their prisons, pretty much for the entire spectrum of the criminal justice system in each state. Is that a true picture, or you think we have a structure that can accommodate state police in the judiciary as it is currently formed?
Well, we have state judiciaries, we have federal judiciaries. There's nothing remarkable about apportioning powers and rights to various levels of government, be it executive government. There's going to be a subsidiarity from the federal government to the states, from states to local governments, and in some countries where they have federal systems, goes down to mayors of cities. Subsidiarity in government is recognized as a desirable principle. The idea that government should be administered at the lowest possible level so it is most effective. Now, as to criminal justice, this again is not a remarkable thing. Theft, public urination, sexual offenses, these are offenses that are properly within the remit and control of the more subsidiary levels of government as can be appropriate. So the magistrate court, you don't expect the Federal High Court to deal with public urination. So you've divided the legislative and legal responsibilities. You would also assign courts at the different levels to deal with those levels of offenses. There are federal offenses, offenses dealing with currency, offenses dealing with foreign exchange, dealing with defense, with banking and securities. Those are national subject matter. This is not a remarkable thing again. From the creation of our country, there have been debates as to how to assign legislative powers to different levels of government. And this has changed from time to time. From the various constitutions, they decided certain issues should be with states. And state police had originally been a local government matter. Before independence and thereafter, we did not have a centralized, we had an inspection of police, but the fact is that you had local government police. And that is a practical solution to the problem of crime and punishment, that you should bring its administration to the lowest level where they can identify the local thief and they know exactly who is the local
Unfortunately, Mr. Candid Johnson, that seems not to be the system we have right now. Dr. Shitu, usually sometimes at the end of the day, it's in the execution of some of these issues. Let's imagine for a moment that we now have an active state police system in the country. Mr. Candid Johnson was talking about the First Republic. We had local government, police, so to speak, at the time, and they had their own impact on the polity. Imagine for a moment that we now have a state police system. Do you think the judiciary, as it's currently structured, can easily accommodate it without any rancor?
There's no doubt about it that the judiciary can easily fit in. I think the first reality that we must face is that this constitutional framework that we are practicing is a gross deception. Gross deception in the sense that we claim to be operating a federal system of government. A federal system of government. And central to federalism is true fiscal federalism. We don't have a centralized policing in the federal setup. It's an anomaly. I think we must recognize that. You practice this is a unitary system of government that masquerading as a federal setup. In an ideal federal setup, you decentralize powers, including policing powers. You don't have, for instance, under the present, dispensation that we have, the governor of the state is not in full control of the police. He's not in control of the police. That's the reality. The police is answerable. The commissioner of police in Lagos State, for instance, is answerable to the Inspector General of Police in Abuja. In a federal setup, that is clearly an anomaly.
How is that problematic for the judiciary?
It's problematic because, like we all know, that most of these offenses that we're talking about, they are local. You understand me? If a murder is committed here, in Lagos State, it's the the local police that will investigate. It is elements who are familiar with the terrain that could track the perpetrators of such a heinous crime. You don't ask somebody who is from Zamfara to come and police a state in Osun. He doesn't even know the terrain.
But Mr. Shitu,
So, but there's no way we can even talk about this subject of state policing without a constitutional amendment.
Exactly what I want to say now.
The Constitution does not allow it.
So if everybody is saying
Yes.
that our Constitution needs a tweak or an overhaul, what's stopping Nigerians from saying this Constitution is not representing our interests as much as we want, is a hurdle to a lot of things? Why can't we do something?
Well, we are only doing so. Part of this discussion.
You know, we've had a lot of constitutional amendments.
I mean, this conversation is also about that.
Mr. You know, we've had a lot of constitutional amendment meetings in different states by different administrations. But it seems like once we have the beautiful blueprint and suggestions put together, and it just goes quiet.
I think we are going about it the wrong way, in my view. What we need is not tinkering with the Constitution. We need a brand new Constitution. We need to start afresh. We need to subject a constitutional, framework to a referendum of the Nigerian people. This is lacking now. Were you called upon? Was your consent or your input sought before this Constitution was put in place? So we must agree that what we are operating presently is defective, fundamentally defective.
Let's take it to Mr. Candy Johnson. First, do you agree that we need a brand new constitution? I read a lot about how to go about this. The argument, I think, from one of the senior advocates, your colleague, that said, let's look at Section 4, which gives the National Assembly some level of powers to be able to write a new constitution, take this one out as a draft, and put a proper law and all the technicalities. So first question, and two questions in one because of time. Do you agree we need a brand new constitution, that this piecemeal amendment is not working for us? Second part is another elementary issue we see within lower court, assuming jurisdiction over cases that Supreme Court has clearly pronounced. Classic case. I'm sorry I always bring in politics because that's where the biggest embarrassment of litigations comes from. Where the Supreme Court has mentioned that issues around membership and leadership of political parties, don't bring it here, except it has to do with nomination based on Section 8415 of the Electoral Act. But we see lower court assuming jurisdiction, and then you see them forum shopping and giving concurrent judgment from a court of coordinate jurisdiction. So two questions in one, sir.
Okay, well, as to the Constitution, I think that we can certainly benefit from, we would benefit if we had a new constitution which reflected the fundamental values, the ideas, identity of the Nigerian people. And when people talk about constitution, the lawyers talk about it as if it's a legal document. In fact, it is a record of the fundamental social, cultural, and political agreements, including the identity of the people whose territory it governs. So I don't think that anyone can discern from our present constitution in its piecemeal form any consistent idea as to who Nigerians are. And I think that it would benefit from that sort of improvement. But of course, the political task of creating a new constitution is massive. I think perhaps they could do it, but we would first of all need to agree on the fundamental basis of our organization. What do we believe in? Do we believe in the right to life, property? Do we believe in the freedom of association? All these things we take for granted. If those are the basic things, I said earlier, the U.S. Constitution had 7 articles because to unite 13 colonies or more, they only needed to agree the fundamental things about life, about liberty, about the fundamentals of their economic organization. So that is that aspect of the question. I think that our constitution is problematic. It's inconsistent and in many respects incoherent, and it would benefit from drastic improvement, which may include a complete substitution of the constitution. As to the question of judges ruling and assuming jurisdiction on matters where there is a clear judicial Supreme Court decision that they cannot do so. This is judicial misconduct, and it is likely to be the result of corruption. A judge, you must assume a certain level of competence from a judge. And when a judge does something that is patently out of the pale, especially when there's a direct authority to the contrary, then we must start from the assumption that he has intended to pervert and corrupt that process and that decision. And that's how the Judicial Council should review it. If a judge gives a decision directly consistent with the Supreme Court decision, that is misbehavior, and such judge ought to be punished.
I must thank you both, senior advocates. Sorry, if we were to talk about political litigations, we'll stay here till tomorrow, but we don't have any more time. I must thank you both for coming. Yomi Candy Johnson, a senior advocate of Nigeria, thank you for joining us virtually. Also, senior advocate Leonard's sake as well, we're happy to always coming through whenever we call. Thank you. And you look like we're going for a traditional marriage.
It's a good way to start 2026.
And I must just appreciate Mr. Kande Johnson. I learned a lot from him growing up as a lawyer, even in Kano. So I'm happy to share the same podium with him on this occasion.
We're happy to
have you. It
continues
to be a pleasure to associate with you.
We're happy to have you both. So thank you so much.
Right.
Well.